Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We had previously apprised you of the status of the so-called Idaho4 civil defamation case. This is an action that has been pending in federal court in the United States District Court of Idaho since December of 2022. It is styled as Rebecca Scofield versus Ashley Guillard. We now have the order setting the trial available for you to review. This is a 6-page document. There's many items that are addressed here. First and foremost, one, the trial date is a 4-day jury trial. It is set for Tuesday, February 24th, 2026, beginning at 9 a.m. Pacific Time in Coeur d'Alene, Idaho. And as the footnote here says, plaintiff's complaint was brought in the Moscow, Idaho division and demanded a jury trial. There is no longer a federal courthouse in Moscow. Therefore, unless otherwise ordered by the court or agreed to by the parties, the jury trial will take place in Coeur d'Alene, Idaho. And then directly underneath paragraph 1, we see the pretrial conference dates. There are 2 of them that have been scheduled by operation of this court order. Pretrial conference is scheduled to take place at 10 a.m. Mountain Time on February 5th, 2026, to discuss and resolve insofar as possible 1. The legal issues remaining in the case. 2. Evidentiary issues. 3. Trial logistics, including exhibits and witness lists. And number 4, any other matters pertaining to the trial. And then it continues on to page 2, on or before January 29th, 2026. The parties shall communicate and reach agreement on as many items as possible, including stipulations related to the parties' proposed exhibits. This should include stipulations on foundation or other evidentiary matters, even if there is disagreement as to whether a document should be admitted into evidence based upon relevancy issues. The parties shall be prepared to discuss with the court those items over which counsel and party disagree. So if I could interject my thoughts, my opinions here, at this pretrial conference on the 29th, the court wants the parties to have communicated with each other, as parties do, before this hearing, to try to resolve as many issues as possible regarding the parties' exhibits. Recall, this is a case for damages only. Liability has been found in favor of Scofield. So this is simply for the jury to determine what, if any, damages Scofield should be awarded. We've done some prior presentations on this case to go over what the complaint alleged in terms of Scofield was and presumably still is a professor of the University of Idaho, and she alleged that Ms. Guillard, who was, as described in the complaint, a TikToker, produced YouTube videos, and Scofield alleged that she was defamed because Guillard was asserting, using her psychic abilities and so forth, that Scofield was involved in the crimes at 1122 King Road of November 13th, 2022. As stated here, this pretrial conference will be held via Zoom, so it's going to be virtual. A second, now this is in person. The court wants to see both sides in the courtroom, scheduled to take place at 10 a.m. on February 23rd, 2026, to discuss any outstanding issues ahead of trials. And then it goes into the Daubert motions regarding any experts, witness lists, expert lists and exhibits, dates for these things due for court filing, which The first of which is coming up very soon, the Daubert motion, due September 2nd, 2025. Witness list coming up due in October, and then so forth. And you can read the rest of this court order for yourself. Paragraph 6 deals with the jury instructions, how the jury should be instructed by the court. These are proposals that both sides will file by October 7th. Proposed verdict forms, voir dire, which is the process of selecting the jury. Proposed voir dire matters are due October 7th, and then the trial briefs. Typically what a trial brief will be, the legal issues, the factual issues of the case as seen by both sides, is typically what you will see in the trial briefs. And then any in limine motions, any rulings sought to be rendered by the court, in limine motion, application for a court order in limine before trials. These are due October 14th, with the responses due October 21st. And then any replies October 28th, or within 7 days after the filing of any response to a motion in limine. And then this is always a good time to address briefings. What are briefings? Briefings consist of 3 filings: a motion that the initiating party files here in limine if there's any rulings that they want pre-trial, and then the other side has the due process right to be heard, and that would be the response, usually in opposition from the party opponent, although we've seen situations where there's agreements on matters. And then ultimately the reply is one last opportunity. Whoever filed the motion has one more opportunity to try to persuade the court to rule in their favor. You don't get to go back and argue your entire motion in limine again. It's supposed to be contained strictly in replying to the response. And then you get into trial procedures, rest of page 4 and going into page 5. I'll leave you with the opportunity to review this on your own. And then 12 on the clock. As of right now, plaintiff is allocating 50% of trial time and defendant is allocating 50% of trial time, which will be determined once jury selection is completed. The court will keep track of the time each party uses and will adjust the number of total hours expected for trial depending based on what happens at trial each day. So what does this mean? The parties have said whatever amount of time that's allocated for trial on damages, which this court order says it's 4 days, 50% of the time the plaintiff is saying they're going to need 2 days. The defense is saying they're going to need 2 days. And so this will bring us to the conclusion of the order that was rendered by Judge Raymond E. Patricchio. He is the Chief U.S. Magistrate Judge. If you have any comments, thoughts, opinions, please leave them here. And until next time, this is Kathy. Thank you for joining us here today.